Judge Schroeder.
I see it's live, but I don't see. Okay. I was waiting for a second attorney to appear.
I
Mr.
think
Wood
we
is in the waiting room. There he is.
There he is.
Okay. I thought I had that correct, but welcome to this afternoon session of the Kansas Court of Appeals. Today we have one argument on for oral argument this afternoon. It's in the matter of the marriage of Asten. Our case number is 121-350. Today the panel consists of Judge Henry Green, who joined the court in 1993. Earlier I had used the wrong date. And to my right is Judge Mike Boozer, who joined the court in 2005. My name is Kim R. Schroeder. I joined the court in 2013. And with that short announcement, I would say that this case involves an appeal from a divorce out of Miami County, where the parties have been married and are now divorcing for the third time over a 20-year period. The issue before the court is not the amount of maintenance, as the parties agreed to the maintenance, as I understand the record. The issue is over how long the order for maintenance should be. With that, I'll let counsel make their announcements. And Mr. Booth, I think you're the appellant, so if you would like to give a few additional facts for the parties who may be watching this action that are not aware, give them a little background, I will allow you to do so, and will not count that time against you. With that, counsel, please reflect your appearances.
Ronald Wood appears on behalf of the wife, Laura Van Asten. I'm with Clyde and Wood.
Your Honor.
Proceed.
I'm getting double feedback. I don't know whether it's on my end or whether other people are hearing that, but as long as you can hear me fine, is that all right?
I'm hearing you okay. Judge Green?
Yes.
Judge
Yes, I'm hearing fine.
Okay. Okay.
You may proceed when you're ready. And do you wish to
I may
reserve
have a hard
any
time.
for rebuttal?
5 minutes.
Okay.
Thank you. May it please the court. I'm hearing the same feedback at the same time. I wonder if I should go out and come back in.
I think once you leave, you can't get back in.
Okay. I'll just try to. All right. Let me get started. Sorry about that.
Is that better without the
Yes.
earphones?
Yeah, I think that fixed it.
Good deal.
Okay. Joseph Booth appears on behalf of the appellant, Mr. Van Asten, Brian Van Asten, and I wish to reserve 5 for rebuttal. This is a matter, we all know that when the district court makes a determination in a divorce, both for spousal support and for the division of property, that they enjoy a wide range of discretion, and this court is not going to disturb that on appeal unless there's been an abuse of discretion. This is a situation where the judge found and actually articulates in the decree that after 27 years of family law practice, both on the bench and in general practice as an attorney, that he wound up surprised by what the Allen case felt made him rule. And he saw the Allen cases requiring him to take the 3 separate relationships punctuated by 2 divorces in the center and treat them all as one. I think he had a confirmation bias kind of response to what the Allen case really does stand for. And, you know, the Allen case for one measure is that all those inchoate issues that were left over from a separation agreement are voided by marriage unless it's otherwise clearly articulated in the separation agreement. And the other interesting and very helpful point that the Allen case makes is that that previous separation agreement is an excellent source for determining what the parties had before they remarried, which we often do in practice. If we're looking for premarital assets, we'll look to previous separation agreements. So that standard isn't any different than what we have here. But by reading the Allen case in the way he did, the Judge Montgomery was trying to do the best job he could and follow the law, but he overread it, in my opinion, and we're arguing here. He wound up saying that it took him longer to rule and that he had a very different result. So as a matter of appeal on the standards of abuse of discretion here, this error is an error of law, and that's the primary basis for which we seek a remand and for him to re-rule based upon clarity in the law. And as I've read the Allen case several times, there's nothing in it that even indicates in the slightest that you'd take sequential relationships. So under the facts in this case, the parties were in a situation where they had two separate divorces before. One of them punctuated by a fairly short period of time, but the other one lasted it was about 2 years, 2 to 3 years, from May of 2011 to August of 2013. So that'd be 2. You know, they separated their property, each wound up with their own individual property, whatever they chose to do with it, whatever the reasoning was for not having or having maintenance. I believe that Judge Montgomery was actually thinking that Mr. Van Asten was asking the court to not order maintenance because it had been waived 2 times before. They said that in the transcripts, and he may have hung on to that, but they were not asking for the court to be bound by either of the 2 earlier separation agreements. What they were asking was for the court to recognize, one, the history of the parties, and if it is an important point of fact and argument that she had waived maintenance 2 times before. That leads to factors such as economic interdependency. And it also, I believe, is an important factor if the court's going to even think about considering this series of relationships that started and stopped within the history of this family and wound up not making it all one concurrent piece. We know that the judge considered it all one concurrent relationship because he showed his math. He used the Shawnee County guidelines, and he used the total of the relationship without talking about any period of separation until he adjusted from what the presumptive amount on the guidelines would have been 71 months down to the order that he made by having it to 31 months, I believe it was.
So, Mr. Booth, if I'm not,
yes.
I believe I'm correct. The parties agreed to use the Shawnee domestic relations guidelines, and the judge said, well, if I looked at this as a total number of months of marriage, it would be 215, which would, under the guidelines, result in 71 months of maintenance. And your client's position was that maintenance should be based only on 61 months of the 4th marriage because it only lasted about 61 months. And then the court said equity dictates that the term for payment of maintenance should be reduced from the maintenance term otherwise imposed, which would be that 215, for a continuous single marriage of this duration. And then he said, I'm going to half it, and that would be 71 months to 35 months with giving your client credit for temporary support payments. Bottom line is that your client was ordered to pay 18 months of maintenance on a 4-year marriage. Is that about right?
Not the way we see it, Your Honor, because the period of time between the date of filing, which was August of 2017, all the way through to the trial, which is in January of 2019, he was paying that maintenance. And in my practice of matrimonial law, the obligor of support is credited for those interim payments made between the time the parties separated, usually about the same time the petition's filed, and the time of court. So under his suggested math, he would have already completed all required, basically 1/3 of the length of the marriage. He would have already basically had that paid.
Well, you didn't appeal that as an error, though, did you?
We appealed that because the court took it into the consideration, the idea of the duration of the marriage, and even though they used his equitable powers and issued a shorter order, the reason for the calculation is based on the reading of Allen. And the court was very clear about that. And so the calculations show that the court looked at the entirety of the relationship, including the cohabitation before they got together, had a very long relationship, and calculated an award that would have been based upon the whole, and then looked at the equities of the situation and reduced it to half. But if you look at it, if you wouldn't have misread the Allen case and treated the whole series of relationships as one continuous relationship, then the order would have been less. So yes, that question is on appeal, and that's how we expressed it in our briefing.
I guess then my question would be, assuming that he did not use the 215 months of marriage originally, which he later modified, what is your position as far as what the appropriate number of months of maintenance should have been ordered? Properly reading Allen and all the other cases.
Yeah, Allen doesn't give us any guidance, would be our position. And the Shawnee County guidelines basically would put it to about 1/3 of the length of the marriage. And that's pretty standard across the state of Kansas in my practice. The duration of maintenance is about 1/3 of the length of the marriage. So you take the total number of months in this relationship that lasted between August 13th through to August 17th, those almost exactly 4 years. And you would have wound up with about 1/3 of that time, whatever that turns out to be, like 15 or 18 months.
And he ordered 35 months.
Right. All the property division and the maintenance division and everything was centered around the idea that he doesn't get premarital interest because he was married to her before, and when you conjoin those marriages, so he winds up paying with a different outcome than you would normally expect, the way Kansas judges apply equity to the considerations in the statute.
Well, I guess I'm a little confused. Are you saying that the order allowed him credit for the temporary maintenance to reduce the number of months after the divorce decree? Or is it 35 months post the divorce decree?
The order allowed for credit for maintenance that had been paid, and I believe that we just read that. Judge Boozer read that, and then so he was given credit for that period of time between whenever he started paying. We know when he filed and we know when he made an answer, but the Judge Montgomery calculated that there would have been 17 months that had already been paid, if I remember his journal entry correctly. And so he acknowledged that was part of the duration of maintenance. And that's the way I've seen almost every maintenance case work out, that whatever the duration of maintenance is, it's certainly the way we do it around Johnson County, and the practice that I have in both Leavenworth and down in Miami County. They adjust that period of time from the presumptive amount found in some of these guidelines that we all share.
So then he's actually arguing over 18 months because he'd already paid 17 months, right?
Correct. it and the effect that this decision had on the property division.
And what effect was that?
He was not given credit for the premarital, and he wound up with a property division that wound up not recognizing those premarital assets
Well,
in the shorter marriage.
I thought with regard to the division of the marital estate, we determined that the net to the wife was 17,000 some. The net to the husband was 73,000 some, which totals about 90,000. And then he divided it by 2 for a 50-50 split, which came up to about 45,000. And that ended up with an equalization payment that your client had to pay for $28,000. Seems to me that the court said, okay, you brought all this property in to your last marriage here, and we divvy it up. This goes to mom, this goes to dad, and did a 50-50 split on a 4-year marriage. And I'm trying to see where the error would be in that.
Generally, there's a credit given for what you brought into the marriage. And in this case, the previous divorce, the divorce number 2, they split up their property and each was awarded shares, respective shares. And so they theoretically started in a 50-50 position on that day. And then we turn around and commingle those again, which of course the statute does do that. But what we traditionally do is then give people credit for the premarital interests that they had. And my client argues that he was not given the appropriate credit for the premarital interest. Because if you go back to about page 5 of that journal entry, you have even Judge Montgomery saying, I would not have figured this case this way, but for the effect the Allen case has, and it's still good law.
All right, I've given you some leeway on your time. I'll give you a minute to wrap up.
I'm fine. I'll stand for rebuttal.
Thank you, counsel. Mr. Wood?
Good afternoon, Judge Schroeder and Judge Green and Judge Boozler. I introduced myself earlier as Ronald Wood. I'm with Clyde and Wood. Also, good afternoon to Joseph Booth. This is my first Zoom hearing in front of the Court of Appeals, so usually we have a podium and it's sometimes it's easier, but anyway.
That's all right. We're all pretty much novices at this right now.
At my age, I am, but first off, I think we have to look at the statutes, and that's that KSA 23-2802, which says that the property shall be divided whether owned by either spouse prior to marriage or acquired by either spouse in the spouse's own right after marriage, or acquired by spouse's joint effort. So really that statute gives the district judge, a lot of leeway as to how he's going to divide the property. And as one of the cases talks about, is that one lady got 90% of it and the husband got 10%, and then they came back later and wanted to change that. And I'll get to that in a little bit. But then the other statute is the maintenance statute, is KSA 23-2902, which indicates the court may award to either party an allowance for future support denominated as maintenance in an amount the court finds to be fair, just, and equitable under all the circumstances. Now, Judge Montgomery he's a district judge in Miami County. Well, and he does all the divorces in Miami County, but he practiced in Shawnee County, and he likes the Shawnee County guidelines. And that's what we that practice in Miami County regularly, we understand that. I don't know that we agreed to that. It's just that we know that's what Judge Montgomery wants us to use. But you know, they are not the law. I mean, I think we've seen that in the past, is the guidelines are guidelines, and they're helpful for the attorneys and they're helpful for the court, but they're really not the law. They're just guidelines, and they've not been taken up by the legislature or by the Supreme Court. We believe, that if you look at my brief, and I'm not going to go through all of the brief, but that they had an agreement, and whatever went into the reasons the agreement was signed on the first time they were married, there was nothing in that saying that this was going to be used later on. And, that wording could have been put in there that this is a premarital agreement or this is going to be binding upon the future. But of course, we as lawyers never think that these people are ever going to get remarried again because they hate each other so much at the time that we didn't think they ever would get remarried again. But in this case, they got married a second time. Well, lo and behold, they reached an agreement again on this time. And once again, the wording wasn't in this case. Well, I think, when I start doing my research and I come across the Allen case, and I think, Judge Smith decided this case. It went to the Kansas Court of Appeals. It's the type of, the wording on it specifically indicates that a property settlement agreement in the syllabus 2, that a property settlement agreement entered into as a result of a divorce is abrogated by the remarriage of the same parties. And then it talks about syllabus 3 about needing specific language in that. And so that it says the agreement will cease to be in effect upon remarriage except to define what property each brings into the subsequent marriage. Okay, well, that doesn't mean that the next judge is bound by what they did on that. All it means is, we define it and we see it. We go back to that and we look at it, and that's what we look at, but we don't have to accept that because, if the woman was destitute and the husband had $1 million, and would you say that, okay, she gets nothing in this? I think the court has a lot of discretion to say, well, that's not going to be fair, even though in the previous agreement, she got nothing and they've not accrued anything other than that, but we're going to send her out without anything. And so I thought the Allen case was very helpful in discussing the case or discussing this particular type of case. And we don't get a lot of these. Like Judge Montgomery said, he's never in 27 years had one where they remarried. Well, this is not one just where they remarried, but they twice. So this is their third marriage. And so that was an issue that the Court of Appeals said was an issue of first impression. And they cited the different cases in that. And then in my brief, I've talked about it as a judge era that Professor Elrod discusses this same types of things, and they talk about the executory. Well, if there's child support or something such as that, might be a little different. But as far as what Professor Elrod says is that, you got to put this wording in these agreements. And I've told other lawyers, since this time is this the wording we need to put in our agreements is that this is a premarital contract or will be used later on. And so that's the problem is the Allen case just has not been overruled. And it's been cited in 2 other cases that I put in my brief that are not published cases, but I did cite those. Now, in equity, we didn't get the full amount pursuant to the guidelines, really. We didn't get, the judge used equity and said, okay, I'm just going to knock it to 31 months. And then knowing that she had been getting money, and you see the witnesses, the judge sees the witnesses and sees their abilities to live on their own. And doesn't it seem right that maybe another 18 more months to get her on her feet because she's the differences in her incomes have been such that he's always made more. And maybe she shouldn't have waived the maintenance in the first agreement or the second agreement, but she did. And she didn't have a lawyer knows. You go back and look at those cases. There was no lawyer.
And of course, counsel, isn't it true that the Allen case tells us that even if there is a maintenance waiver in the prior agreements, in the prior marriages, that doesn't have any effect on the last marriage?
That's correct. Yes, that's completely true. That's what we argued, that wasn't applicable because of the Allen case. And you know, in this particular case, the wife's exhibit number 7 sets forth that they were together, began living together in August of 1998. And then I went through all the times they were married. They never separated. Then it's another 6 years of marriage. And then they moved back in 2012 pretty quickly. And then they remarried in 2013 and then 14. So, I mean, we had in that exhibit, there were 19 years they were together. There were 13 years they were married. And she really, you know, maybe she should have complained, hey, the guidelines should have given me a little more than this based upon the Allen case. But we thought, well, you know, the court gets to look at these. We did not believe there was an abuse of discretion in the case. I did talk about in my brief that, you know, the Stuckey case was the one that cited Allen, and I thought was an important case. And that language could have been put into these if needed. I mean, as far as the decision, we believe the judge was right in his decision, and we believe that it should be affirmed. The court should be affirmed, and it should not be reversed in any way. That's what all I have.
Thank you, counsel. Mr. Booth?
Turning back to the effect of the Allen case, one really very important observation is, first, the court clearly articulated that it was basing a different decision than it would have otherwise based upon Allen. Nowhere in the litigation did Mr. Van Asten decide to argue that somehow the court was bound by the earlier 2 agreements, which Allen essentially means that. Allen says that when you get married, the executory pieces of that earlier agreement are extinguished, and that the only thing the previous agreement's really good for is to tell you what your premarital assets are. Whatever change was made based upon that error of law. And we can theorize what the order would have been had he not made it very different than he would have in other cases. But he didn't say that in his decision. He said, I'm going to make a different decision, one that he delayed making, and he did more research and he worked hard on because of what Allen requires him to do. And Allen didn't require him to treat this family any differently than another family who had just been married for 4 years, but had been married to other people earlier in their lives. And we know that from the black letter of the decision, that this judge made a different decision, believing that Allen somehow controlled, and it does not.
All right. Counsel, any questions? Or judges, do you have any questions?
No.
Up here.
No.
Well, thank you, counsel. I appreciate the argument. We'll take the matter under advisement. We strive to get all our decisions done within 60 days, and we will do our best to maintain that past pattern. With that, this session of the Kansas Court of Appeals is adjourned.
Thank you, Your Honors.
Thank you. Have a good day.
Thank you, Mr. Wood.
Thank you, Mr. Booth.